114052, State of Kansas v. Ashley.
Good morning, Your Honors. May it please the Court. Sarah Ellen Johnson of the Capital Appellate Defender Office appearing today on behalf of Mr. Ashley. Your Honor, I would like to request 3 minutes for rebuttal, if I may.
3 minutes is granted.
Thank you. We are here today on a murder case out of Shawnee in Johnson County, Kansas. Larry Grovenberg, proprietor of Mr. G's liquor store, was found dead in his store on I believe it was a Saturday evening in May of 2010. Around 9:20 in the evening. The last customer who had been in was at about 20 minutes before then, so we know that was the window of time when Mr. G was murdered. Approximately a month later, my client, Mr. Ashley, and his cousin, Larry Marshall, were connected to the crime through the use of a gun at a different scene, a scene where Mr. Ashley was actually the victim of multiple gunshots. The case stalled at that point until about 3 years later when Larry Marshall, Mr. Ashley's cousin, was arrested, and at this point he turned on his cousin and pointed the finger at Mr. Ashley. And that is how Mr. Ashley was convicted of this felony murder and attempted aggravated robbery. One of the other pieces of evidence that was central to the case, and where I'd like to start our argument today, is the testimony of Tyler Roberts, who was a jailhouse informant who on his own volition, went to authorities in Johnson County and said, "Hey, I was with Mr. Ashley as we were being booked into the county jail, and he confessed this murder to me. He told me he had killed this white guy in Shawnee and was going to prison for life." Now, after Mr. Roberts was allowed to testify, the defense requested that the district court give a cautionary informant instruction, urging the jury to consider with caution the testimony of an informant like Mr. Roberts, who comes forward potentially in search of benefit to himself from the state. Following this court's directives from the most recent case, State v. Lowe, from 2003, through a line of cases that started around 1997, based on my research, the district court said I cannot give that instruction because this Supreme Court has said it does not apply to this sort of informant. It only applies to an agent of the state, somebody who was working with the state at the time that he procures this information.
Are you asking for a cautionary instruction in this case? And my question has to do with some of the research that you pointed us to indicated that really, in instances like you're claiming the prejudice that occurred here, is that a cautionary instruction really doesn't remedy the situation.
That is,
and you point us to that, and so, but then you want that remedy for something that you're, for authority that you're relying on, saying that really isn't sufficient.
Well, that is correct, that the law review article that I found urges a much more drastic remedy. I am left with the request that was made to the trial court by defense counsel, which was for this instruction, and it is certainly the least that we can ask for to remedy this kind of testimony, but I think it's at least a fair start. It's better than the situation that we have in the state of Kansas now, which is that this testimony simply comes in and we don't guide the discretion of juries in considering it at all. So I think that a cautionary instruction is at least a
It
start.
comes in, but it is subject to pretty vigorous cross-examination and examination, the type that your expert, at least the law review article, says that's essential. I mean, they attacked the benefit that he got, his recollection, and everything that had to do with it. The state had a chance to rehabilitate, but it was tested by, it wasn't that it just came in untested.
Well, it was tested in that minimal way. One thing that I think is critical to remember is that the accomplice instruction was given as relates to the testimony of Larry Marshall, and I think that draws a critical parallel that then the jury is told, look at Mr. Marshall's testimony with caution, but then not told to consider Mr. Roberts' testimony the same way, which I think in some sense actually bolsters Mr. Roberts' testimony, which then of course has the side effect of bolstering Mr. Marshall's credibility as well, because now you have two people saying that Mr. Ashley committed this murder, said that he shot this guy. I would suggest that cross-examination is, of course, a vital component of a trial, but there's something additional about an instruction from a court. The court informing the jury how to consider evidence, what evidence is to be considered in what fashion, and we allow courts to do that. And by not having that kind of instruction, we're leaving the jury without any guidance. Given what we now know about the dangers of this testimony, how easily it's fabricated, how difficult it is for the defense to truly rebut. Mr. Ashley has no way to rebut that he was in the booking room with Mr. Roberts at the same time. He had the property that Mr. Roberts must have seen. What he can't rebut is the most incriminating part of Mr. Roberts' testimony, which is the easiest thing for Mr. Roberts to fabricate, what he said. There's no audio recording of this, which is another reason why this kind of informant is perhaps more dangerous than the confidential informant, who is usually in a controlled situation where the police are working with him from the get-go, and so there is a recording of the conversation. All the more reason why this kind of testimony is more problematic and more deserving of at least a cautionary instruction. The power of hearing somebody on the witness stand saying, "This defendant told me he committed this murder," is something that cannot be understated. And in fact, the research that I pointed you to also talks about that moment, that sort of gut reaction that a juror is going to have to hearing somebody say, "I heard the defendant admit to this crime." There's only so much that cross-examination can do to counter that gut reaction, which is why this testimony is so powerful and so problematic at the same time.
Would you require a same type of cautionary instruction on any eyewitness or any witness who said the defendant told me this?
Not necessarily.
Or is it just someone who is in custody and maybe has something other to gain? When is it that this should be given?
That would be
because I mean, you say there's nothing more powerful than someone recounting what was said, admitting to the crime. That happens all the time. So when would we give a cautionary instruction? When wouldn't we?
I would suggest, as in this case, when we have an informant who comes forward of his own volition while he's in custody, or having been in custody and having a pending case against him. This was not an eyewitness at the scene of the crime. This was not somebody connected to Mr. Ashley in any other way. There was no reason for the police to go looking for this guy. There was no reason for them to think he was a witness, to interview him, to think he had any information. He's simply a guy in jail who now sees, hey, I've talked to a guy who's on a murder charge. Maybe this will help me out.
What about someone who's not in jail? Just someone who has charges pending, who shows up at the police station one day and says, hey, I heard you arrested Mr. X. I've got things I want to tell you about what Mr. X told me. I mean, why would it not extend to that person as well?
That could be a fair extension, and it may be something that would come down to, for a person who's not in custody, sort of the totality of the circumstances, the sorts of things that I've talked about with Mr. Roberts. Does he have any obvious connection to this defendant, to this case?
Isn't the cautionary tale whether the witness has something to gain?
Correct.
I mean, isn't that I mean, if you, if the state pays witnesses, hey, I'll pay you if you saw it, so I'll pay you if you come testify. I mean, that would be the cautionary tale in that
Correct.
circumstance, right?
And that's a thing that actually happens, informants in the jail have a detective that they know real well, and they call him up and say, hey, I've got more information on a couple more guys.
Did Mr. Roberts obtain a benefit from the state in exchange for his testimony?
He certainly hoped to.
But did he?
That I am not sure was established at the time.
Wouldn't you need to establish that in order to, at a minimum, make what I think it's pick 51-100, I think is the instruction that was requested? wouldn't the defense have to at least provide some evidence of a benefit in order to make that instruction factually appropriate?
No, I think that would be a mistake as a requirement because that makes it such an easy workaround.
Well,
for
that's
both
what
the
I'm
informant
just
and the
asking.
state.
Maybe you could get a different instruction, but the instruction that was requested talks about the testimony of a person who in exchange for benefits from the state. And if you don't have that exchange for benefits, how can this particular instruction be appropriate?
Well, first of all, just because the person is testifying for that benefit doesn't necessarily mean, in my view, that the exchange has to have already happened. That is the motivation for the witness to testify. But also, there may be a better way to phrase this particular instruction. This defense counsel was working with the more root problem of this court having foreclosed the idea of any sort of cautionary instruction, and so was presenting the instruction that exists and asking it to be extended to this situation. So it may be that we would want to reword that instruction going forward. But I think a cautionary instruction for this kind of testimony is a necessary step to take to prevent the kinds of wrongful convictions that these jailhouse informants have been connected to. And we know this now, and there's no good reason not to extend this cautionary instruction or a cautionary instruction to this kind of informant testimony. If there are no more questions, I wanted to briefly touch on the third issue in our brief, which was the defense requested that the district court not give a 6455 limiting instruction. And I see that I'm running very low on time, so I would simply submit that we allow the defense to waive all sorts of things. We don't require the defense to accept the not testifying.
Doesn't the statute require that the judge has to when there's evidence of other crimes and civil wrongs? And here there specifically was evidence that was presented at trial of your client's prior crimes, prior to and post event or homicide. The statute requires giving limiting instructions in those circumstances, doesn't it?
There are lots of things that are required that the defense can waive. To me, I don't understand why this would be something different, where the defense in this particular case was very concerned that this was an unguided instruction that wasn't even clarifying what the crimes were, and that it could easily be taken by the jury to include the police officer's testimony that there was a gun in the car, that suggests some criminality, when in fact there was no criminality, having a gun in his car. The Highland shooting, Mr. Ashley was the victim in that crime, and it's quite clear he was the one who was shot multiple times. And nothing about this instruction guided.
Well, there was also evidence that he engaged in shooting also from the nurse.
There was speculation that,
Well,
I mean, he also said if he'd had a gun, he wouldn't have been shot that many times, so there was testimony both ways. But the point is that if the defense does not want a particular instruction, in this particular case, they were concerned it countered the theory of their defense, in fact, and courts are required to give instructions that support the defendant's theory of defense when there's evidence to support it. The claim here was that Mr. Marshall's testimony was pretty much the only thing, and the jury would either accept it or not, and so this instruction simply piled on to the general idea that Mr. Ashley is a criminal and not actually guiding the jury's discretion in any way. I see that I'm out of time. I would ask this court to reverse Mr. Ashley's convictions and remand this case for a new trial.
Do we have any questions? Thank you, counsel.
Thank you.
Mr. Chief Justice, and may it please the court, the cautionary instruction was not justified in this case because Mr. Roberts had not received a benefit from the state. If you go back through, as was elicited in his testimony, Mr. Roberts was in revocation status on an existing case that he had already been convicted of at the time that he testified. He also had the prospective possibility of being charged in a subsequent marijuana possession case. Even after this all played out, and even after Mr. Roberts provided the state with the information that he had, and that the state then used in this trial, Mr. Roberts' case proceeded to a revocation hearing. And at that revocation hearing, the state did not offer him a modified sentence. They did not agree to recommend to the court reinstatement to probation or anything of that sort.
Is all of that developed in the record of this case?
It is. And in that revocation case, the state asked the district court to remand Mr. Roberts to prison. They were not giving him a benefit in that case. There was the prospect, as I outlined in the state's brief, there was this uncharged case hanging out there over Mr. Roberts. An investigation had been underway that tied Mr. Roberts to a possession of marijuana charge that was uncharged. So while it can be said that Mr. Roberts was hoping for a benefit in that uncharged case, that information was never even kept from the jury. And to say that the cautionary instruction was warranted here...
Was the uncharged case discussed with him prior to testimony? Was there any kind of understanding that the state would not pursue that uncharged case in exchange, or would consider any kind of consideration
I
in relation
believe-
to the uncharged case and his testimony?
My understanding was that to the extent any discussions occurred, the state informed Mr. Roberts and his attorney they were going to hold off on making any decision until he testified. And so there's inferences there's allusions that could be drawn. And that was what the jury was told as well. That's what was developed within the record. And so I think what happened here was much more valuable to discredit Mr. Roberts than just what a cautionary instruction would have afforded. And that was Mr. Roberts was subjected to vigorous cross-examination. Not just his cross-examination, but from jury selection to opening statement, a theme woven throughout the defendant's theme of this case, his strategy of this case was the state's got some snitches, the state has some crooks that are going to come in and have a story to tell you. They have a tale, and they're hoping to use these pieces of information as a get out of jail free card. And these people are looking for a statutory way out. Those were all lines that were used by defense counsel in this case to discredit Mr. Roberts. This was all information the jury heard. They heard this from opening. They heard it through his testimony. They heard it even earlier in jury selection. If Mr. Roberts' testimony was to be looked at skeptically, I submit to this court that already was occurring. And a cautionary instruction that the jury wouldn't have even heard until a day or two or three after Mr. Roberts got off the stand was a minimal impact on this case compared to what defense counsel was able to do by just excoriating Mr. Roberts on the stand through and through from every single statement that he made.
Can you articulate or give me what your objection is to our cases seem to indicate that in order for this instruction to qualify as an instruction that needs to be given, there has to be a state agent. In other words, some sort of prior arrangement to when the statement is received, and an instruction that the same instruction or a similar instruction being given when anyone in confinement comes forward with a purported confession. I mean, why is the fact that it's an agent make a difference, and why would you object if it's given in one scenario? What's really the difference in the other?
In this case, I think the state objected in large part based upon case law, decades of case
Right,
law
I
saying
understand.
it doesn't apply. But
Right.
academically speaking, as an intellectual argument, and I don't know that the appellant has narrowed it down to just informants who are in custody. I think she even sought to expand it beyond that. But I think the rationale would be, in some of these cases, you don't know if a benefit's going to be incurred or not. Even after Mr. Roberts provided his information to the state still sought to send him to prison. And to say just the prospective hope of some possible benefit down the line justifies giving a cautionary instruction.
Why not?
I-
Why not? Why isn't that the culprit or the problem here? Is, it doesn't cost you anything, except perhaps the retribution in prison, but it doesn't cost the witness anything to say that, and the potential benefit is there. I mean, if someone is in a position to possibly benefit, why isn't that something that needs to be addressed.
Well, perhaps it is going forward. I don't know that in this case it necessarily applies. In part of the rationale in this case, I argued harmless error, if this court finds it to be a mistake, is that there was a mountain of evidence against Mr. Ashley related to this killing. And that is outlined in the brief, and even at the appellant's opening, when she stated that when Mr. Marshall came forward and informed the state, told police about his cousin's involvement, that's, I believe her words were, that's how he was convicted. And it's true. When Mr. Marshall came forward and unraveled the case and played it all out for the state, that's when the state was able to look at cell phone forensics and tie it all together. The ballistics tied it all together. Mr. Ashley was not just a victim in the 40th and Highland shooting. He was a victim in that shooting. He had been shot. But in the vehicle that he took to the hospital was a casing. In the passenger, between the passenger seat and the door on the floorboard was a casing to the gun that matched the casing found at Mr. G's homicide. So there was a mountain of evidence against Mr. Ashley. Mr. Roberts' testimony was minimal in terms of the impact that it possibly ever could have had on a jury. Furthermore, even if this type of instruction is warranted going forward, I think the question next becomes, when is it going to be used? It's not uncommon for there to be reluctant witnesses in cases, to high-profile cases, even smaller cases, saying, I don't want to come forward, I don't want to testify, that's not something I don't want to be involved. And the state does say, you get mileage reimbursement, you get a witness fee if you come in. There are things the state does to secure witnesses' presence in court. Does it apply then? Is a $10 witness fee for coming in for a day's worth of testimony constitute a benefit that the witness incurred by the state, such that that witness's testimony will then be told to be heard with caution by a jury? Will a jury then be instructed, hey, that eyewitness, their testimony should be viewed with caution because they received a benefit? They perhaps won't be told what the benefit was. But what I would submit to this court, it was much more valuable that in terms of minimizing or tearing down Mr. Roberts' credibility, the impact that defense counsel was able to have on all of his statements in cross-examination, it was vigorous and it was lasting and it was impactful. It was impactful because it occurred within minutes of when Mr. Roberts told the jury, I heard Mr. Ashley admit to this murder. Within minutes of him saying that, that's when defense counsel was able to tear him apart. And I would submit that a cautionary instruction that would be told to the jury down the line would have essentially no impact in how they viewed his testimony.
See, I have a little problem with that. If it wasn't going to make any difference, why would you not just let it happen?
Perhaps that is what this court should say happens going forward. I think it does draw, like I said, some of the questions, though, about when exactly is it applicable. If we're now going to expand it from a category of persons who have received a benefit from the state or who are working for the state at the time they receive the information, if we're now going to expand it to all people who possibly hope to prospectively receive some unnamed benefit in the future that we can't even define, I think that opens us up to saying there needs to be a line drawn sometime, and I don't know where that line is. I think where the line is now is a reasonable place, especially when defense counsel is able to impair the credibility of that witness through examining his hope for benefits. It's not as though, even in the absence of this cautionary instruction, it's not as though Mr. Roberts' desires for benefits were ever withheld from the jury. In this case, the jury heard all about the benefits that Mr. Roberts hoped to procure. Furthermore, the jury was instructed in this case that it's their task to decide the credibility of witnesses and the weight of all the testimony and the evidence in this case, and they can use their life experience and common understanding to make their assessments of witness credibility and the weight of evidence and testimony that was given. That's precisely what happens in cases like this. So it's not as though defense counsel's cross-examination of Roberts was meaningless, because that was all valuable and that was all allowed to go to the jury, and they were instructed, use your common sense. Common sense is going to tell them, a witness who was in jail with this individual who heard this, who's now saying, I hope the state doesn't charge me with this marijuana possession because I'm coming forward. A jury's hearing all that. It's the same information that would have been in that cautionary instruction. It's not as though the jury's going to turn a blind eye to all the information, or blind ear to all the information they heard about his impaired credibility. In terms of the limiting instruction was proper in this case, not just because the statute mandates such, but because this court has mandated as much in cases. It isn't as though a limiting instruction when evidence of prior crimes or wrongs comes in is somehow discretionary with the district court. It has been stated in the statute, State v. Wilson 2012, stated if 6455 evidence is admitted, the district court, quote, must give a limiting instruction. And that's what occurred in this case. The district court gave the limiting instruction that it knew it was mandated to give. This was 6455 information, not just on its face, not just to us reviewing it now, the fact that the jury heard information that Mr. Ashley had aborted an earlier attempt to rob Mr. G's liquor store. They heard that information, but it wasn't, obviously that constitutes, to an attorney hearing that at its face, that sounds like 6455, but it was 6455 information on the record in this case. There was a written order from the trial judge stating as much, because a hearing had been held on the state's desire to admit this information, as well as the possession of the gun earlier. So a written order was issued well in advance of the trial by the district court judge stating this evidence is coming in for these reasons under 6455. So everyone knew that a limiting instruction was appropriate and that it would be coming. To say that he should be able to waive the limiting instruction makes things a lot hairier for this reason. Number one, when it goes against him and he ends up being convicted, inevitably that appears to be the kind of thing that would come up in a later hearing, perhaps a 1507, saying, oh, we waived that, but my attorney said we should waive that. We shouldn't have waived that. Now I got convicted. We should have told the jury that information that was 6455 should have been limited for its admissibility. Furthermore, there are certain aspects of strategy that a defendant cannot waive. As was mentioned earlier by this court in an earlier case this morning, there are circumstances where lesser includeds cannot be waived, where you cannot put all your eggs in one basket. So it's not as though a defendant has full free reign over all aspects of his strategy and all aspects of the instructions that are to be given to a jury. He cannot waive every aspect of that. And I would submit he shouldn't be able to waive the limiting instruction that's appropriate when...
This was kind of a generic limiting instruction. Do you see any danger in proceeding with something like that, or to making it more specific? Like you gave the example of the aborted plan, maybe the shooting. Should it specify those particular that particular conduct, or should it just be generic? I think that was part of the concern of the defendant. It's like, hey, it's all this behavior. They may think it's just all of it's criminal. What about that?
And I think the argument cuts both ways. On one hand, I can see the concern over the generic instruction. On the other hand, I often hear, I don't want the specifics put into the instruction because then it draws attention to it. And it offers to a jury or suggests to a jury there were other crimes here that the state could have charged but didn't, and so on. So I think the argument can cut both ways, that the instruction should be generic or that it should be specific, leaning on particular aspects of evidence that were admitted. In this case, the evidence that was admitted, I think, was pretty clear. The aborted attempt and so on, I think that could be reasonably understood by the jury to be the information. I don't know that there were other aspects of the evidence presented against Mr. Ashley that a jury could have construed as being criminal. I think the one that would be at the forefront of a jury's mind, anybody that had sat through that trial, what would be at the forefront of their mind was that the fact that they had gone there and aborted an attempt days prior would clearly constitute criminal conduct. So I see that my clock is about expired. Unless there are further questions, I will pause, but to ask for this court to affirm Mr. Ashley's conviction and his sentence. Thank you.
I see no questions. Thank you, counsel.
Just briefly, I'd like to remind this court that most of this mountain of evidence that the prosecution cites comes from Larry Marshall's testimony himself. There's no question that the same gun was involved in the Highland shooting as the Mr. G shooting. The question is whether Mr. Ashley was the one using that gun at either scene. And it's Mr. Marshall's testimony that provides that information. It's Mr. Marshall's testimony that provides the information about this claimed aborted attempt and the actual shooting. Mr. Marshall, who has a documented history of pointing the finger at Mr. Ashley. He in fact has an alias because he's been arrested claiming to be Bruce Ashley before so that he could himself avoid having a warrant. So that's another point to consider when considering this mountain of evidence against Mr. Ashley. When we consider whether this cautionary informant instruction is necessary, I would submit that at the very least, Tyler Roberts' testimony fits this specific identifiable category of testimony of a jailhouse informant, a person who is in custody, provides incriminating information that he comes forward with on his own, hoping to receive some benefit. That is a minimum category of informant who I would suggest merits a cautionary instruction. The problem with waiting until we see if he actually gets a benefit or saying, well, he didn't get a benefit in the end, so you don't get this instruction, is that the motivation remains the same for this informant. Mr. Roberts doesn't know that he's not going to get a benefit when he's providing this testimony. If we say you don't get this unless and until you get the benefit, then all the state has to do is not provide the benefit until after the defendant is convicted, which we already know is
like it said it was going to here.
What?
Just like it said it was going to here. We'll reconsider
Precisely.
your uncharged crime.
And that is the very easy way for the state to get around treating these informants as what they are, which is jailhouse snitches hoping to get something by simply not providing the benefit until later.
And it's the way in which the state can ensure that the state gets its side of the bargain.
Correct. That at a minimum then is what I would suggest following the definition of jailhouse informant from the research that I provided. Tyler Roberts fits that. A cautionary instruction was warranted relating to Mr. Roberts' testimony.
Counsel, just briefly as a matter of legal theory, I guess, why should the court ever weigh in on the credibility of witnesses?
I've thought a lot about that question in the run-up to this argument. The fact of the matter is that we all here have more information about the ins and outs of the criminal justice system than the jury does. We know more information. We give a lot of instruction to juries about how to weigh eyewitness testimony. And that's because we have all seen over the years how this testimony weighs out what should be considered, what maybe shouldn't be considered. We have this information, and I think it's incumbent upon courts to...
Courts should tell juries what they can and can't consider. Those are questions of law. So you can exclude evidence from a jury's consideration, either by actually excluding it or by telling them not to consider it. But this seems to me to be qualitatively different. You're not telling them whether they can or can't consider it. We're telling them how they should consider it.
Correct.
And it seems to me like that, that at least arguably invades the sort of quintessential role of a jury, which is to make those determinations.
To me, it's important, though, for those of us who have the information to provide that to the juries. We know more about...
Jury needs a helping hand, basically.
The jury deserves to have the information that the courts and the legal system has.
Why can't they get that through a witness? In other words, we've said that it was error to exclude expert testimony on sexual abuse victims' testimony or child, that kind of thing. So why shouldn't this be presented through witnesses that say that this is, the defense puts on a witness that says this is unreliable?
I would certainly agree that that would be appropriate testimony. I don't think that cuts against giving an instruction as well. After all, we now allow eyewitness identification experts, but we still give that instruction.
Right.
You want a limiting instruction, but you do not want it for the 6455 evidence, correct?
In this particular case, the defense did not want that instruction, And our position is that that is something that the defense should be allowed to waive, as they're allowed to waive so many other things throughout the course of a trial or a criminal proceeding.
And if we were to agree with your argument on the cautionary instruction about this jailhouse informant, as you say, that too should be something that the defendant should be able to waive. Is that right?
I have no argument against that. Instructions are something that defense can request or request not be given. It's a strategic choice in a lot of cases, and I'm not willing to foreclose the idea that there would ever be a strategic reason not to give that instruction.
Very well. Any more questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.